whether or not there's compelling reasons, we invite you to look at the... Sorry, Honor. Sorry.
The issue that Mr. Awele
Yes.
is very critical.
It is the reason that I have said I'm concluding on that issue so that I don't go on the issues of facts. I think that was guidance.
Yes.
I am very well guided. And in conclusion, we invite you that when you retire and look at the matters of fact on the affidavit vis-a-vis the prayers in the application, you find that indeed there has been established compelling reasons to deny it. There are two questions of law that are left, which I conclude with. Edwin Shisanya Amboso versus Republic is a decision of the Honorable High Court, Justice Mugambi, that you've been referred to. We have agreed, and it makes sense, that there is a distinction between the orders granted in Edwin Sishanya, which rejected an invitation to declare assemblies unconstitutional or to issue conservatory orders to that effect. The charges before you are in respect of a criminal offense defined under Section 77(1) of the Penal Code. We admit and agree with the defense that there exists orders of the High Court upholding the right to assembly.
Thank you.
We, however, are saying that what we have brought before you is charges for alleged criminal offenses which will be determined upon hearing. Finally, the question about the dates on the charge sheet, I would have referred to three provisions of the Criminal Procedure Code. One of them, Section 89(5). There was no invitation from the defense or any allegation that there was any impropriety on the charge sheet. And there's no order of this court rejecting charges, which would have happened under Section 89(5). Number two, Number two, Section 382 of the Criminal Procedure Code provides for an allowance in error of dates and names, among many other errors, and so that will affect the validity of the charges. Number three is that this court has the powers to direct suo motu or upon application by the prosecution to amend charges. That is still available. And that power and right exists all the way until before the accused is placed on his defense. In conclusion, Your Honor, you have been invited to send a message. I'm only concerned about the message you're sending to the prosecution. We plead with you that we have not shown, or you've not been shown any fault on our part to send any message. But even if you should, your role in this matter is to determine under Article 49(1)(h whether or not there are compelling reasons or not to release the accused persons on bail. If that is the manner you're going to show or send us a message, we welcome it. No, you're not talking from it. I'm neither. There's the issue I've been reminded about place of detention. Should this court not be able to make a determination in the next few minutes? And I have been advised by the Deputy Director of Public Prosecutions, who I am pleased to be leading me today, that we are not objecting to the accused persons being held at a police station. However, she has advised me that the police officers will have a discussion with where to place them, which police station to place them.
Let me tell you one off record. The day they'll arrest you, they'll take you to Cancun. That is a honorable member of parliament. Let us treat our leaders with respect, away from the police.
Yes.
When I was dealing with the SSU matter, I'm only talking to him as a friend. This is off record, Your Honor. Off completely record. I'm advising him.
We can talk about this off record outside.
Well, I'm only advising state officers.
Your Honor, again off record as he sees, he has applied to be my boss. Your Honor, we are done. I'm just reiterating that we have no objection to the accused persons being taken to a police station. And when you become my boss, we will still do this.
Thank you. Your man under me will be very different.
Thank you, Your Honor, for your time.
Your Honor, very. I know it's completely out of order, but I couldn't fail but notice one thing which my learned good friend did mention. That ordinarily the decision to charge takes about 14 days. But they did it within a record 4 hours, which of course we commend, even though we have reason to worry about the speed at which they approved that charge. Secondly, some of the suspects who were in Uhuru were also driven here at extremely high speeds. So that means I'm just speaking to the urgency in resolving this matter and still renewing the plea that we made before you. Understanding, Your Honor, that really you've had a long day. And if we can get a decision from you before we depart from this court, we will be greatly indebted to the court. But in the event that then at the earliest, Your Honor, I just thought that a good gesture such as this of approving charges within 4 hours should be met with an equally good gesture of this matter being determined within the shortest time possible. So, Your Honor, but I leave it entirely up to you. I just wanted to point that, and I'm sorry because I know this is out of hand.
But you know, there's only one more aspect that I'll address you on, the question of the phone belonging to the first accused person. Yes, sir.
Now, please. I start sharing another application.
We'll address you in the day when you come in the next 30 minutes to deliver the ruling.
If it were not because of the large number of people in the courtroom and the consequences of not hearing you to the end, we would not have gone up to the